What's up, guys? Let's talk trial. Today we're going to talk about the cross-examination of Dr. Fowler by the prosecutor of Blackwell, and how that went, what I thought about it, how we can improve by learning some of what was done, and how we think the case is going to develop based on that cross-examination. So if you haven't really been watching the trial, the prosecution just finished cross-examining Dr. Fowler, who is the defense's basically main medical witness. He's the guy that's going to come in and say, or that did come in and say that George Floyd did not die as a result of the excessive force allegedly used by Officer Chauvin, but rather that he died because of the heart issues combined with the drug issues, combined with a whole bunch of other things that are not the fault of the cop. And so he testifies reasonably well. You know, there wasn't anything crazy happening on direct examination. There were some things that were just weird, or kind of I found them unusual, but there's a whole other video I'm going to make on that. But for the most part, it was a pretty effective direct examination. And so the prosecution got up there to cross-examine Dr. Fowler, and I frankly was not expecting anything super legit, reason being that prosecutors are usually not very good at cross-examination because they don't get to cross-examine witnesses often. So basically, prosecutions, if you've been prosecuting 30 years, you may have cross-examined 20 people in your career, because for the most part, when you're trying cases, most of the time, the entirety of the trial is you putting on witnesses, and those witnesses being cross-examined by the defense. So I really wasn't expecting much. And then the prosecutor got up there, Prosecutor Blackwell, and he did a what I consider to be a textbook expert cross-examination. He actually did an excellent job on that cross-examination. And when you're cross-examining an expert, there's certain things that if you're going to do an effective cross-examination, you are going to do. And this is for every witness, but specifically for expert witnesses. Number one, you're going to challenge the expert's credibility. The reason for that is because if you're cross-examining an expert, it is the expert for the other side, and that expert is going to hurt you in the direct examination, meaning the reason they get paid is to come to court and hurt you. So if you're cross-examining, you have to do something to make the jury understand that that expert should not be believed as to what he or she is saying. So you got to challenge that credibility. Number two, you stay away from the science unless you have something concrete that you're going to hit them with that is going to be very easy for the jury to understand that you're right and the expert is wrong. And 99% of the time, that's not what happens. 99% of the time, even if you are right, it's kind of hard to convey to the jury that you know more about the science than the expert does. Because after all, you are a lawyer and the expert is an expert in the field that they're testifying about, which is not law. It's, medicine or engineer or whatever the expertise is on. So usually you stay away from the science unless you have something concrete to hit them with. And the prosecutor did that very well in this case. They didn't really get into much of an argument, if any, regarding scientifically what was true and what wasn't true. What he did do, which was pretty legit, was he used what's called authoritative sources to impeach or to challenge the doctor's credibility. Basically, he asked him questions about whether certain books are books that medical examiners, that forensic pathologists rely on, and it's part of the training curriculum for forensic pathologists. And when the expert said yes, then he basically said, all right, let me read to you some pages from these books that you have acknowledged that are authoritative in the field. And the stuff that he was reading was very contradictory to the opinion of the expert. So basically, he impeached the doctor with an authoritative source, actually with two authoritative sources, in a pretty clean fashion, and it was very, very effective. And he stayed away from the minutia of fighting with the guy about stuff that he really did not have him dead to rights on. And so that was very, very good. So challenging credibility, obviously, it's key. The second thing that you want to do with any witness, but especially with an expert witness, is you want to see how much you can agree on. Meaning, if there are things that are favorable to your case, and you can get the other side's expert to agree with you on them, then that's something you always want to do, because the other side's going to be unable to challenge the things that their own expert agrees with you on. And so he did that very well for a few things. He did that very well in regards to the things that the doctor had to admit. And in doing so, he was narrowing down the scope of what's going to be at issue for the jury ultimately. He's going to be able to get up there and say, look, these things are not at issue because my experts say they're not at issue, and their experts say they're not at issue. So you don't have to worry about those things. You can accept that both experts agree that this is what happened. And so get rid of that way. Another thing that he did very well in terms of challenging the credibility of the expert without getting into the science is attacking what the expert did or did not do. So his expert was testifying about the intake of oxygen and how this George Floyd's oxygen intake would not have been affected by the police officers and all that kind of stuff. And also testified about the CO2 emissions from the car that George Floyd was put next to on the ground. And so he gives all his testimony, and then on cross-examination, the prosecutor got him to admit that he's done no measurements, conducted no calculations, and in no way whatsoever quantified anything that he was talking about in regards to those things. He's just saying them. So when it comes down to challenging the credibility of an expert, if you can attack the underlying data of the expert that the expert's relying on, then you can make good progress, because it could be that they know very well what they're talking about, but if they haven't really conducted any measurements or they haven't really done anything to calculate what they're saying, then how credible, how reliable is that testimony going to be? So that was very good. And the other thing that the prosecutor did that was very, very well done was to correct the expert on the name of the tumor that the expert had been testifying about for like 3 hours. I don't know if it was like paraganglioma or something like that, but the expert was adding an N in the middle. So he would be saying stuff like, I don't know, paraganglioma, as opposed to paraganglioma, or whatever the actual name is. And he'd been saying this name for like 3 hours. In fact, at some point in the direct examination, the defense lawyer was saying it right, and the expert corrected the defense lawyer and added the N, right? So now everybody's talking about this paraganglioma. And then come to find out on cross-examination, the prosecutor made him admit that that's not the correct terminology, that it does not have an extra N in it. And the way he did it was consistent with the way you do something like this. Like, he wasn't making a big deal out of it. He wasn't just being rough about it. It was just like done in passing, in a quick in and out kind of question. But it was clear to everybody that this guy was wrong the whole time about that word. And you may be thinking, well, what's the big deal? Like, what does it matter? It's one end here, one end there. Any little thing that you can do to an expert to make the jury wonder whether they know what they're talking about or not is something that's going to be good, something you have to do in cross-examination. So that was very, very well done. He also corrected the expert because the expert had testified that there was no amphetamine in George Floyd's bloodstream, which would indicate that the methamphetamine that was consumed would have been consumed shortly before he died, meaning there was not enough time for the methamphetamine to break down into amphetamines, which is the byproduct or what meth turns into after the blood or the body processes it. And the expert had said that there was no amphetamine, and therefore that indicates that some methamphetamine had been ingested shortly before George Floyd died. On cross-examination, however, the prosecutor gets the expert to admit that he was wrong about that there was, in fact, amphetamine found in George Floyd's bloodstream, and therefore that means that methamphetamine had been ingested at some point further in time than what the expert was originally saying. So all of that was very, very good. There was a lot of good things that were done in the cross-examination. I was very surprised to see it. There was a couple of bad things that happened, though, in the cross-examination, something to learn from. Number one, the cross-examiner on like 2 or 3 occasions basically just flat out cut the witness off and said, it was a yes or no question, I don't want you to explain anything type of stuff. And I know some lawyers like to do that, but that, to me, if you're a normal person, if you're a juror, if you're somebody just watching this trial, and you see the lawyer not wanting the witness to explain the answer, the first thing you're going to think about is you think the explanation is going to hurt you. You're like, you don't want me to hear what that guy has to say. You just want him to answer specifically in a very confined way because you're worried that when he puts in context the answer, that is going to be hurtful to your case, and you don't want me to see the full picture. That's not ideal. Ideally, you don't want to come across like you're hiding something, because anytime the jury gets any inclination that you're hiding something, they're not going to trust you. And if you lose the jury's trust, then that's going to be a problem later on, really, for the entire case. So that wasn't great. Not the biggest deal in the world, not the craziest thing, but obviously it was not ideal. It was not the best thing. The second thing that was not great was an impeachment with a deposition transcript. So there was an impeachment. Basically, the prosecutor challenged the witness on some testimony the witness had given in a civil case. And the actual challenge, or the actual testimony, was the doctor had testified on direct that you would require over 200 to 220 pounds of weight in the position that George Floyd was in order to impede his breathing to any significant degree, right? The prosecutor's impeachment was, well, you testified to this before, and he reads the testimony from the deposition. And the testimony was, it would take several officers to do that, to basically to cut the breathing or to impair the breathing of George Floyd. And the prosecutor's impeachment was, well, you never said it would take 200 to 220 pounds for that to happen. But that's like lawyer stuff. We lawyers, we think we got some big point we're going to make, and we're like, oh my God, I'm going to get up there and I'm going to get him on this deposition. But when you think about it like a normal person, if the testimony was, it would take several officers, right? Several is more than two. More than two is three or more. Let's just say it's three for the purpose of argument, right? Three is the least amount that several could be reasonably interpreted to mean, right? If you have three people in the United States of America who are cops, what are the chances that those three people combined weigh less than 200 pounds? You would need to have a crew of three cops who weighed like 65 pounds each with clothes on for that impeachment to make any sense. In reality, the testimony in that point was consistent. If you have three police officers, and that's what it would take to affect the breathing, then what he's saying basically is you're looking at somewhere in the 300-pound range. So it's actually worse than what the prosecutor intended to get, because on trial, the witness is saying 220 to 240 pounds or more. The previous testimony was basically, he's talking about like 300 pounds when you're being reasonable about it, because you're going to have, let's say, 120-pound police officers to 180-pound police officers. Let's say on average, you're talking 150 pounds times three. That's like 450 pounds of weight. So that's way more than what he testified to on the stand. Now, if the prosecutor intended to make the opposite point, which was, well, like 2 years ago, you said it would take 450 pounds, and now you're saying it takes 220 to challenge that math, then he could have. But the way that it was done was the opposite of that. It was intended to elicit an answer of basically this 220-pound number is not a real thing. It's less than that, right? Which wasn't really the way it panned out. But anyway, so overall, I think it was a fantastic cross-examination. It was clean. It was tight leading questions for the most part. It stayed away from the dangerous areas. It was a fantastic job. So I looked up the guy who did the cross-examination, because I figured, that's not typical cross-examinations you see from prosecutors. And obviously I got a lot of friends from prosecutors, so no offense to any of you, but you'd have to admit, for the most part, the majority of prosecutors cannot cross-examine to a high level, mainly because they don't practice it enough. So I looked at the guy to see who he was, and it turns out he's actually not a prosecutor at all. He is a civil rights attorney, basically a plaintiff lawyer that does civil cases, most of which are against police officers, and convincing juries that what the police did was unlawful, and it resulted in injury or violation of civil rights or death or whatever the case may be. So that kind of explains a little bit how he is performing at a higher level than you would expect from a typical prosecutor. And that's because, as a plaintiff lawyer, he does get to cross-examine a lot. Most civil cases involve both sides putting on a case, as opposed to criminal cases. In most civil cases, you're going to have multiple witnesses for the plaintiff, and you're going to have multiple witnesses for the defense, and both sides pretty much have to cross-examine and hone that skill, and the more you do it, the better you get at it. So anyway, guys, that's it for now. That's my take on the cross-examination of Dr. Fowler. And I'll catch you again next time. Let's see how the trial ends up wrapping up. Take it easy.